Please be seated. We are here at the time set for oral argument in file number 2025-0367, Emily Cowan versus Dr. Guy Slann, the Williston Foot and Ankle Clinic, and CHI St. Alexis Health of Williston, another name for Mercy Medical Center. Sitting this morning are Justices Jared Tufte, John Jensen, Douglas Barr, Mark Fries, and I am Lisa Fair-McEvers. Arguing this morning for the appellant, Emily Cowan. Is it Cowan or Cowan? Cowan, thank you for correcting me. Is Mr. Nathan Severson, and appearing along with Mr. Severson are Kylie Carlin and Emily Cowan. Oh, I don't see her here. She's behind you. Okay, all right, there she is. So counsel for the state in this matter, arguing this morning is Reed Johnson, a law student, and appearing with him is Mr. Philip Axe. And counsel for Mercy Medical is Tracy Kolb. Before we get started this morning, I do want to welcome the students who are here visiting from Velva High School. Welcome. They're here with their teacher, Ashley Peterson. So thank you. I hope you enjoy the argument this morning. Mr. Severson, when you're ready, you may proceed.
Chief Justice Fair-McEvers, Justices of the Supreme Court, Mr. Solicitor General, Counsel, may it please the Court. My name is Nathan Severson, and along with my co-counsel Kylie Carlin, we represent Emily Cowan, who's the appellant in this matter and is here with us today. On November 7th of 2024, a jury of 9 in Williston, North Dakota, who had heard evidence of Emily Cowan's injuries following a wrong side surgery that left her with a progressive, incurable, chronic pain condition called complex regional pain syndrome, unanimously found that her non-economic damages totaled $2.36 million, and that CHI was 65% responsible for those amounts. The jury deliberated carefully. It sent a note to the court asking at one point to clarify the distinction between economic and non-economic damages. It reached a unanimous verdict. That verdict was binding. Juries have been rendering binding verdicts on damages in private tort actions since before North Dakota became a state. The question before this court is whether the legislature can override the verdict under Article 1, Sections 13 and 20, when we are here about private litigants. This court has never decided that particular issue in the private defendant context. As this court held in Berry versus Truax, the right of trial by jury had obtained a fixed meaning in the jurisprudence of the territory as defined by statutes, which existed prior to and at the time of adoption of the Constitution. It is that right that is so understood which Section 13 and 20 secures. The duty is to ascertain whether the right as it was known in 1889 included the aspect that the legislature has now overridden. There isn't a dispute on that answer in the sense that no territorial statute capped non-economic damages in private tort actions in 1889. The jury's verdict on damages was binding, not a recommendation for the court to accept or reject, but the final word on what the plaintiff's injuries for pain and suffering was worth. That was the fixed meaning of the right. It was fixed at statehood. Now, North Dakota Century Code, Section 324202, substitutes a predetermined legislative number that was initiated in 1995 for that verdict, regardless of the evidence, regardless of the facts of the case. The legislature decided in 1995 that no matter what the jury found, whether it be $1 million, $2 million, $500,000, and $1, the answer would be the same. That fixed right, as it was established in 1899, has not remained inviolate because of that. A word on Section 20 in Article 1. In 1889, Section 20 now known as Section 20, said, "To guard against transgressions of the high powers which we have delegated, we declare that everything in this article is accepted out of the general powers of government and shall forever remain inviolate." The people adopted that language to prevent exactly what happened here, the government substituting its own judgment for the jury's verdict. The power to override the jury's verdict was never within the legislature's general powers. It was accepted out. So every dollar that the legislature takes from the jury's verdict is a dollar the Constitution and the people that initiated it said belongs to the jury. A verdict that the legislature has predetermined it will override is not a verdict, it's an advisory opinion. Section 13 does not guarantee North Dakotans the right to an advisory jury. Now, to be clear, under the fixed rights at adoption framework, the legislature's policy goals are not part of the Section 13 analysis. The question is whether the right has remained inviolate, not whether the legislature has a good reason. And how do we know that government interest doesn't matter in this context? Well, if we consider Section 16 of the same Article 1, this has to do with eminent domain. It says that the right to just compensation when property is taken has to be determined by the jury. That the amount has to be determined by the jury. If the legislature, say in 1995, capped just compensation in eminent domain cases at $500,000, the jury would still find the fair market value. The cap would only affect the recovery. Under the state's theory, that statute would be constitutional. But I would respectfully submit that it would not be, because when the jury renders its verdict on value, the verdict and the recovery are inseparable. The jury serves as an impartial fact finder, standing between the citizen and a predetermined government number. The jury is the one that's tasked with making sure that the protection is there.
Mr. Severson, I
Yes.
don't think the briefs, at least from what my reading, were clearly articulated the standard of review. Are you asking for a heightened standard of review under the Constitution, or are we doing a rational?
I actually, thank you, Justice Barr. I believe that this is a de novo on whether or not this statute is constitutional, and we don't actually get into scrutiny at all. That's an equal protection area or due process violation. This is looking more to the court's line of cases that's been since Berry versus Truax about the fact that when you have a fixed right at the time of adoption. We confused this issue in our briefing in the district court. We talked about artisan and arbitrariness, and in fact, it was at the oral argument when defense counsel brought up the fact to the district court, arbitrariness has nothing to do with this. That's an equal protection issue. That it dawned on me, that's true. And that's why the briefing to this court, we more talked about the Arneson case in the context of that no matter how laudable the legislature's goals were, they don't have the power to do it.
So then, is that another grounds upon which you're distinguishing the cases relied upon by the defense?
Yeah.
Were completely different analysis?
Yes, correct. Yes, correct, Justice Barr. In other words, it's a different analysis altogether. And in fact, there's two other cases in this court that we'll talk about. Larimore. This court made the decision in Larimore, as well as the Condon case. In Condon, if we start there, Justice Jensen authored the opinion, and it was in the equal protection context. So, again, to your question, Justice Barr, that's a different analysis completely. So the fact that Condon says that it survived in that context doesn't apply in this type of constitutional framework. While we're on Larimore, Larimore does not resolve this case, and the reason is the rights at the time of the adoption of the Constitution framework was never triggered in Larimore. In fact, it went through the process of whether or not there was a dispute, and there was a clear dispute in that case about whether or not, if you look at the Ludlow and I think City of Grand Forks case that talked about corporate municipalities versus what this court did in Quito about overturning governmental immunity, that's why it didn't trigger. That's why Larimore is different than this case. And this court limited the language, I believe, in that context of against a political subdivision. Going on in Larimore, this court discussed about the fact that actually utilizing arneson when going through the equal protection analysis, saying that that doesn't actually apply in that context because it was dealing with political subdivisions. And for that same reasoning, Larimore can't apply to this particular case, because this is about private defendants.
If I recall correctly, the majority of states have gone a different way, although you cite cases that do take your approach. Are they distinguishable based upon what rights existed at the time of their constitutions, or you just disagree with their analysis?
I think a little bit of both, Justice Barr. And the reason is, if we look closely, North Dakota's unique in the sense of Section 20 accepts powers from the government that most, I think all of the other constitutions, if I didn't do that close of a reading, I'm sorry, Justice Barr, to say that with absolute certainty, but Section 20 of our Constitution is different in the sense that it's saying we, the people, are not giving the legislature that power. Those other courts have decided that on different basis. And I don't think that those states have that exception of that power. But on top of that, some of the cases we cited to actually sit in the groundwork that we're talking about today, that I'm arguing about, which is the rights at adoption framework, where those are saying, if we look to the Kansas case, the Sophie case, all of them are kind of saying, look, we got to look at what the rights were at adoption. And when they're talking through about whether it's a remedy versus a fact-finding issue, they all say that the rights at adoption has to win out in that analysis. And that's what we have here too, Justice Barr, is that I understand what other states have done, but this state in 1889 used different language in what it was saying the legislature was allowed to do. And I believe that triggers this court's responsibility to say that the legislature, when they were accepted from that power, doesn't have the power to do what they did under North Dakota Century Code 324202. And we can even look to, Section 13, Article 1, Section 13 itself has been amended, Justice Barr, and that was, I believe it was by the legislature in 1974, if I'm remembering correctly, put it to the voters. And that's when the language was added that they gave the legislature specific authority, but limited authority yet, about the number of jurors that they were going to allow. But they said, but you can't be any less than 6. So we know that the legislature, at least then, understood that it had accepted powers. It wasn't able to make that decision on its own. Initiated a constitutional amendment, put it to the voters approved it, and they actually constrained themselves with it when they actually put the language in there. In 1995, they didn't do that. That same mechanism was available to them to say, let's put this to the voters. They've actually told us that this is not part of the power that we have under the North Dakota Constitution, so let's put it to them. They didn't do that. And that is the constitutional problem with Section 324202.
Mr. Severson, you're distinguishing private actions and private defendants based on the 11th Amendment, or what grounds?
It's because, it's more of the rights as they existed at the time of the Constitution being put into place. And this is kind of going along the line of the political subdivision issue that came up in Larimore, and whether or not there existed the ability to bring a lawsuit against the governmental entities. So it's in that private litigants stage. In other words, this court's decision that we're asking for is going to be narrow enough to say, when we're talking about 2 citizens of the state here, or 2 citizens that are in district court, the rights as they existed that applied in that particular case, a general common law negligence claim, said that there's no cap on damages. That's why it's limited justice freeze. So the reason I also bring that up, though, is that that's why this decision, a decision for Emily Cowan in this particular case, does not overturn Larimore. It does not overturn Condon. This stands on the principles that have been established very clearly since Berry versus Truax under North Dakota constitutional law and what this court's analysis has been.
How do you tell us what sort of rule you're looking for to determine whether something's a remedy or whether it's a part of the jury trial right? Surely there must be some sorts of punitive damages or multiplicative exemplary damages or other types of damages that have changed since statehood. So how do we define which side of the line this is on?
In the context of this particular case, Justice Tufte, we have to look to what the territorial statutes talked about as well as what it was at the time of adoption. And in this context, the only thing that existed at the time that the state has pointed to is that you could have double, treble damages. There were some remedy boundaries and breach of contract actions, but none of those said to a jury, you get to make a binding decision, but then we are going to reduce it. In fact, in the double and treble damages, it said it increased it. It took what the binding agreement said. That's why that's different. So in
that case, are those triple damages constitutionally required in a similar case?
I think, well, they're constitutionally allowed. I guess I don't know. I gotta have to think about the constitutionally required. I think if you look at the rights as they existed at the time, yes, because that was granted to the people when they passed that. I think that's absolutely true, Justice Tufte, if I'm thinking through it on the spot.
Okay, and so the 1889 language spoke to both civil and criminal cases.
Yes.
In the criminal context, certainly we think of the jury right as a right of the defendant. In a civil case, is it a right of both the plaintiff and the defendant in your view, and does that matter to how we think about it?
Well, excuse me, I think maybe this gets to the state's argument about the fact that the double and treble of damages somehow affects their rights as well. Well, that's true, but at the time that this was passed, that was already the law of North Dakota, meaning that the law said that that is exactly how we're going to operate, and the defendants knew that when they voted this in. The opposite was not true, right? Meaning that in this context of what happened in this particular case, when that was passed, the voters understood that the right as it existed was that the jury was to make the binding determination on the pain and suffering, or what we now call non-economic damages.
Is your argument of what the voters understood based solely on what the law was at the time? Or do you have any newspaper articles or any discussions of the constitutional provisions that support what the voters understood?
It's simply based on the law at the time if we get to that framework, because, and if we look, I think we could look a step further about what did they mean when they said secured, and I think this court has talked about what they meant by secured, meaning this isn't granting something new. We're retaining what this right was at the time that everybody understood. So that's where the territorial statutes come in, but it was also saying that it needs to remain inviolate, meaning how did they understand it? But we don't have any of the evidence about what that looked like, other than we know that, and even I believe all parties here do not dispute the fact that there was no limitation on the jury's determinations or under the statutes on this minus remitter.
Are there any constitutional records or anything showing what the intent or what the voters may have understood? Solely the statutory law at the time?
Yes, yes, and that fits within the framework that this court has used, though, I believe, since Berry versus Truax, Your Honor, is that, but we could also, I guess, look to the constitutional, the dictionary definitions of what it meant to be secured back in 1889, or what it meant to say remain, or to say inviolate, and those might help to speak to that issue. And when we're talking about inviolate in that context, to me that means you don't disrupt it. You don't dwindle down from what it was. And if that right was fixed, that the legislature had not made a decision to limit the damages then, you can't change that. And doing that with 324202 has done that. That's violated that right as it existed in 1889.
Mr. Severson, the state, well, the Attorney General in particular, says that your position fails to account for the difference between damages and remedy. And much of your argument is predicated on the laws that existed at the time without respect to that distinction. What is your response to the Attorney General's argument?
Thank you, Justice Freese. First, I think there's a lot of different ways to look at that. Number one, what we've been talking about with the double or treble damages, the damages must be reasonable. We have to look at it in that context, and none of that, again, limited the amount. But on top of that, we have to take a look at the fact that when you're applying this type of constitutional analysis about what the legal fixed right was for the people that voted in and said to the legislature, we're not going to give you the power to do anything with what that right is. To simply try then to say, but we made a remedy. The fixed right has to win out. And that's what some of the cases in the other jurisdictions, I believe, talked about, is that when you have those two, you have to let what was fixed at the time win out in that analysis. The additional thing I would point out, though, is that they have other options, the legislature. They can go and amend the Constitution, and they've known how to do that. And they didn't do that here. Instead, they did exactly what the Constitution said that the citizens need to be protected from, which is to exercise their legislative authority to try and take away something that was an inviolate right at the time of the adoption of the Constitution.
Another question for you, sorry.
Go ahead.
So it seems like your theory of the jury trial right here is that if you could sue for it and have a jury determine damages, at least in the tort context at statehood, that's rights secured. And so it calls to mind, I don't think the briefs mentioned this, but at statehood, I think you could sue your employer for an injury sustained on the job and get a jury to award damages. And then some couple decades later, we have mandatory insurance, workers' comp. Under your theory, how do we distinguish those changes from the changes that you're asking us to consider?
Yeah, I think in that context, there's a quid pro quo. And the cases I've talked about quid pro quo, this isn't that type of case context. But in that case, there was an actual quid pro quo that said, in exchange for some guarantees that you are going to be protected through the workers' compensation system and insurance that happens there, you're going to give up your right to bring the lawsuit. So I think that's the difference in the context here, Justice.
Mandatory insurance in the medical context would be constitutional under your conception of the right?
In other words, if a hospital in a private setting had mandatory insurance, I don't think that changes the analysis. Because
so they can take away your right to a jury trial to sue for your non-economic damages so long as they give you something in an insurance scheme.
I don't believe that would be constitutional in this context, but that's where I think the analysis about quid pro quo, if you look at some of the other jurisdictions, and I think it might have been Arneson that also talked about the quid pro quo analysis, that's where I think that would fit in. Now, I don't know that that's been particularly challenged. I didn't see cases on that. So I don't know how that would come down. If this court's already ruled on it and I'm not aware of it, then that's different. But
I'll explore that further. I agree. I'm catching you on the back foot here. So
Mr. Severson, the folks on the other side are saying this matter shouldn't be appealable because your client accepted the benefits of the judgment. Would you address how this court has jurisdiction?
yes, thank you, Chief Justice Farrah McEvers. If we look to case law that actually from 1894 from this court, the Tyler versus Shea case, it says that acceptance of benefits does not bar appeal when the appeal can only increase, never decrease the appellant's recovery. In this case, that's what we had. If we look historically on this case, we went through and we challenged the constitutionality in the district court about whether or not non-economic damages should be reduced down to the cap. The district court said that they didn't agree with our analysis. The amended judgment that was paid only had the amount of the $500,000 cap. So the fact that we have this appeal, if we are correct on the fact that the 324202 is unconstitutional, it only increases that amount. That's all it does. And that's where it fits in versus the Tyler versus Shea. On the flip side of that, though, CHI, in their own briefing, has stated clearly that they paid the judgment, understanding they were waiving their right to appeal. And they can't manufacture some sort of issue for us because if their cross appeal somehow reduces that judgment.
So if they wanted to appeal, they should not have offered your client the funds, they should not have paid.
That's correct. And on top of that, Chief Justice, if we look to the record that was supplemented by CHI, there's actually a back and forth There was an offer made to our client that in exchange for a little bit lesser amount, I think about $76,000, that both sides would agree to waive appeal. We said no to that. Ms. Cowan said, I don't want to agree to that. I then explored in the email to the other side, to Ms. Sagi, saying that your client can still pay with the interest and all those things to stop interest, because that seemed to be the pressing issue. And they paid it. We did our part of acknowledging that, but we knew when we accepted that this was only, what we were planning to appeal was only going to go above that.
But you didn't reserve any right to appeal in that satisfaction of the judgment.
That is correct, Chief Justice. But if you look to that email, actually, and even after the appeal came, I think is even telling, Ms. Sagi had emailed me, I think it was on October 28th, and said, you signing a new satisfaction of judgment that complies does not change the deadlines for the appeal, something along that line, meaning we all knew that we were going to be appealing this. They knew that that's what we were going to be doing. They simply paid the judgment to stop the interest.
You drafted the satisfaction of judgment and filed it with the court, right? Those emails were not filed with the court?
That's correct. We did.
Is it improper for the other side to rely on the satisfaction of judgment, which said all claims were satisfied between the parties?
I believe if we look in the context, Justice Freeze, of the fact that they knew that they were not buying no appeal. In fact, when we were approached by it and we sent the money, they said that they asked just for acknowledgement of the payment. So we did file the satisfaction of judgment, which didn't comply to the statute. I see my time's done. Thank you.
Mr. Severson. So, Mr. Johnson, I understand you are going to argue first, and you will be arguing, you'll have up to 8 minutes.
Thank you, Chief Justice.
You're welcome.
Chief Justice, Justices, Counsel, good morning, and may it please the Court. My name is Reed Johnson, and I will be arguing on behalf of the State of North Dakota in support of Appellant. The State will be addressing the constitutionality of Section 324202 in context of Article 1, Section 13 of the North Dakota Constitution. Counsel for CHI will be addressing the mootness question and the cross-appeal, the apportionment issue in their cross-appeal.
Mr. Johnson, that's part of the fun of being here, right? We're going to interrupt you and ask some questions, but if we accept the state's position, there's nothing that prohibits us from putting caps on compensatory damages also, is there?
Your Honor, the cap is on non-economic damages. And
I meant economic damages.
Your Honor, no. Economic damages are subject to a different analysis under this court. Actual damages, the economic damages, capping those have run into issues, and this is the Arneson case that counsel writes about in their brief. The cap overall on both economic and non-economic damages was held to violate equal protection. However, this court in Condon has held that equal protection, that non-economic damages caps did not violate equal protection. And that's a good point for this court, that this appeal is regarding the Article 1, Section 13 jury right, the procedural right to ensure the jurors are the finders of fact and make an assessment on damages. The substantive right, what counsel for appellant refer to, that is a substantive right, and that substantive analysis has already been upheld under intermediate scrutiny in Condon. So for the appellant to make the same argument as in Condon on the same statute, but now attack it under the Article 1, Section 13 jury right, the state's position is that the jury right is the procedural right to have a jury hear the facts of the case and make an assessment as to damages. But remedies have always been the legislature's purview under the North Dakota Constitution. This is going back to territorial era statutes and to early statehood. And the state has examples of statutes and early court decisions in its brief that can point to this. And on that point, none of the early court decisions that opposing counsel cites go to the actual remedy phase of the decision. It all is in the liability determination phase, and that is exactly the state's argument, that the jury has always had the power to determine damages, but the court, through the legislature, has always had the power to determine the remedy.
So what's the point of allowing jurors to determine the damages if the person who's been injured doesn't get that? Is that to persuade the legislature to raise the caps?
Your Honor, the cap in 324202 protects both plaintiffs and defendants. So the fact that these are a largely unascertainable category of damages, non-economic damages, there's predictability here given to defendants in the medical malpractice context, just like the treble and doubling statutes that the state cites to protects plaintiffs or discourages bad behavior. So those are both legislative remedies that have been put forward by the state legislature and have been applied at the second phase of a jury's determination. So if the treble right doesn't violate Article 1, Section 13, like the state had identified in Wacker, then the cap could not violate that same jury right just because it works in favor of a defendant versus a plaintiff. So the state's position overall is that the argument rests on a fundamental conflation of damages and remedy. And damages are a question of fact. This court has always recognized that as the jury's province. The jury did hear exactly what it was constitutionally charged to do. It heard the evidence, deliberated, and returned a finding. But remedy, the legal consequence of that factual finding, is a question of law. And the legislature has broad authority to shape the law of remedies. When Article 1, Section 13 was ratified in 1889, the compiled laws of the territory of Dakota contained numerous statutes that modified the legal consequences of jury damage findings in both directions. The scope of the jury right today is defined by the laws in existence at ratification. And if Appellant were correct that Article 1, Section 13 gives juries both the fact-finding role and the unreviewable authority to dictate the final legal remedy, those territorial-era statutes would have been unconstitutional the moment the ink dried on our state constitution. That cannot be the right reading. The principle was demonstrated in Wacker versus Mertz that the state cited to in our brief. In that case, the court reasoned that liability and malice were both determined by the jury. An award was given. The court then applied the statutory treble damages provision to arson with malice. So that's just one example of what the right looked like at statehood, but this court has already addressed precisely this question in Larimore. And the court upheld the statutory damages cap for tort claims against political subdivisions, but Appellant believes that political subdivisions should be treated differently than private defendants. The court did not uphold the cap because the government has special immunity. It upheld the cap because the legally available remedies are, quote, obviously not the same thing as the procedural right to have a jury make findings of fact about damages. That logic does not depend on who the defendant is. A cap that limits the amount of recovery ultimately allowed operates identically whether the defendant is a school district or a private hospital. From the Larimore decision, quote, what was affected was the ultimate recovery post-verdict, which was not a function of the trial here being by jury. This is what the state adheres to, that the jury right under Article 1, Section 13 is a procedural right, that the jury has the authority existing at statehood to hear damages, to make to hear the evidence, to make a finding of liability and damages, but the legislature has always had the authority to shape remedies and to come after that jury has performed their procedural constitutional right to have a plaintiff hear his or her case by a jury. The state also has the constitutional right through the legislature to make remedies. And
So the legislature can just say there will be no remedy for non-economic damages. Instead of a 500,000 or whatever the cap is, they can just say no remedy, period.
Your Honor, that would be a substantive right analysis under equal protection.
From the challenge we're dealing with today, that's the state's position.
The state's position, Your Honor, is
any remedy.
There may be other constitutional theories that would attack the amount under some sort of fairness argument, but the procedural right of the jury is not violated with the cap at 500,000 today. If that cap were $1, it might have different treatment under equal protection, but it would have the same treatment under Article 1, Section 13, which is the jury still had the procedural right to hear the evidence and facts of the case, determine liability, and assess damages. That right was honored in this case. In closing, the right to a jury trial guaranteed by Article 1, Section 13 is a sacred right, but that right has never extended to every aspect of civil trial procedure. Since the time of our state's founding and before, the right has always meant the right to have a jury serve as fact finder. What Article 1, Section 13 has never meant is that a jury's verdict on damages must translate one for one into the final legal remedy. Thank you.
Thank you, Mr. Johnson. Ms. Gould, you have 12 minutes.
May it please the court, counsel. My name is Tracy Kolb, and along with my partner Julia Nierengarten, we represent CHI St. Alexius Health Williston in this appeal by Emily Cowan. I will touch briefly on the constitutional issue. CHI agrees with the state that the non-economic damages cap does not deny a litigant the right to a trial by jury, and Ms. Cowan is wrong when she says Arneson controls, Condon is irrelevant, and Larimore is distinguishable because it pertains to a public entity, not a private defendant. North Dakota is still in the clear majority of states that have non-economic damage caps in medical malpractice cases, and it has a higher cap than more than half of the states. The weight of authority has upheld these caps when constitutionally challenged. To decide the question here, the court need look no further than North Dakota law. Arneson does not control. A 1978 decision, it involved an equal protection challenge to a statutory scheme that was far and wide-ranging, with one of its provisions capping both economic and non-economic damages at $300,000. Unlike that statute, 324202 does not cap economic damages. It permits all injured malpractice litigants to recover all economic damages regardless of the seriousness of the litigated injury. Ms. Cowan's economic damages award totaled just shy of $2.3 million, of which she recovered 65%, or just shy of $1.5 million from CHI. Condon tells us that 324202 is not arbitrary, rather a narrowly tailored solution to what the legislature saw as a concern. Unchecked non-economic damages that are highly subjective, unquantifiable, uncertain, and inherently arbitrary. That was the legislative goal in 1995 and in 2009 and 2025, when it was revisited and unchanged, to rationalize an inherently arbitrary category of damages and bring it within the realm of the knowable. Arneson, however, does tell us what would constitute a violation of the right to a jury trial, when under another provision that was at issue in that case, it is denied altogether. Larimore is dispositive, regardless whether a cap statute applies to a public entity or a private defendant. The analysis of the constitutional question is the same. Summed up, there is no constitutional right to a full recovery of damages on a jury's verdict. It is within the legislature's purview to statutorily modify remedies, including the type or amount of a party's remedy. Larimore makes sense to Ms. Cowan when applied to a public entity, because she says at the time North Dakota's Constitution was adopted, the state and political subdivisions were immune from suit, unlike private defendants. It's an artificial distinction, because that immunity was not constitutionally mandated, as we know from Kiddo and Bowman, and thus a protection that did not apply to either public or private defendants. And 324202's application is not limited to private defendants.
Ms.
It applied.
Ms. Kolb, am I recalling Larimore correctly that the court did not address, the court did not base its decision based upon whether political subdivisions had immunity at the time the Constitution was adopted?
I think you're correct, Justice Barr. I mean, that's not my recollection of the case either. I'm simply responding to the argument that's being raised by Ms. Cowan.
I understand that, but they're making that distinction, but that wasn't a distinction made in the case. Am I correct?
As I recall, You're correct, yes. 324202's application is not limited to private defendants. It applies to healthcare providers and other defendants, which would include state and political subdivision employed healthcare providers. Larimore definitively answers the question here. 324202 does not violate the constitutional right to a jury trial. Its validity is conclusively presumed, and Ms. Cowan has not carried her heavy burden of establishing invalidity beyond a reasonable doubt. CHI did not expect to be here on appeal by Ms. Cowan. It fully paid the amended judgment, and Ms. Cowan prepared and filed a full satisfaction of the judgment. On those facts alone, and based on the law, Ms. Cowan's attempted appeal fails for lack of jurisdiction because a judgment that is paid and satisfied of record ceases to have any existence. The controversy is deemed ended, leaving an appellate court with nothing to review. And that remains the conclusion here, even though there is a non-compliant satisfaction of judgment that Ms. Cowan refused to correct and now insists does not deprive the court of jurisdiction. The court has a complete record before it after allowing a supplemented record on motion by CHI. That record in the law supports that Ms. Cowan waived her right to appeal by her voluntary acquiescence in the amended judgment. Her conduct demonstrates that she fully intended to accept full payment of and fully satisfy the amended judgment. If she intended otherwise, she did not make that known. And even if Ms. Cowan could plausibly argue now that she reserved the right to appeal with no cite to the record, mind you, she was paid and accepted the full amended judgment, which included the $500,000 capped amount for non-economic damages. If Ms. Cowan intended to preserve her constitutional challenge, she would have refused any payment or would have accepted partial payment to not include the disputed portion, the non-economic damages of $500,000. There is no part of the amended judgment that has not been paid or satisfied. Ms. Cowan chose a path that led CHI into believing the controversy was over, only to later try to revive it with this attempted appeal, something that this court has said should not be allowed. Full payment and full satisfaction without the other party's knowledge that a plaintiff plans to appeal does not promote finality, efficiency, or fairness. CHI conditionally cross-appealed because if the court accepts jurisdiction of Ms. Cowan's appeal, it should accept jurisdiction of CHI's cross-appeal. The trial court improperly allocated 100% of the capped non-economic damages to a party found only 65% at fault. This is a sequencing and damages question. Does the court impose comparative fault before the damage cap or the damage cap before comparative fault? It has not been addressed in North Dakota, and the answer is the latter. Apply the cap first and then comparative fault. It is the only methodology that makes sense and avoids inconsistent and incorrect results in its application. This methodology includes considering the cap's underlying purpose. If the purpose is to define the nature and extent of damages recoverable by a plaintiff, in other words, set the ceiling on what pain and suffering, for example, is worth, the sequence is cap first, comparative fault next. And that is precisely the purpose of 324202, to rationalize and set a ceiling on an inherently arbitrary category of damages. The trial court relied on other jurisdictions, one of which from Ohio, the Kuykendall case, is currently on appeal to the Ohio Supreme Court. None of those cases that the trial court relied on has a cap statute or a comparative fault statute like North Dakota. The court should apply North Dakota law, the plain language of the statutes. Those statutes, provided by the legislature, impose two restrictions on the trial court. The trial court must not, one, award compensation for non-economic damages in excess of $500,000, regardless of the number of healthcare providers or other defendants, and regardless of the number of claims. Or 2, allocate compensatory damages in excess of a defendant's proportionate share. To accomplish these legislative requirements, the trial court must apply the cap first. Otherwise, it results in a defendant paying more than its proportionate share, which, when there are other tortfeasors at fault, results in that defendant paying a portion of another tortfeasor's fault and contrary to North Dakota's several liability. And that is precisely what happened here, and not what the legislature intended. Ms. Cowan's appeal fails for lack of jurisdiction. If the court decides otherwise, it should conclude the non-economic damages cap is not unconstitutional, and it should reduce Ms. Cowan's non-economic damages award against CHI to 65% of the capped amount. I have concluded my argument. I do have time remaining, and if the court has questions, I'm happy to address them. Otherwise, I've finished my argument.
Ms. Kolb, it's not, I looked in your brief and you didn't cite it, and I understand why you didn't cite it, but we have addressed in an issue of a certified question, what's the right order of doing offset in the context of awarding no-fault benefits in auto insurance kind of things. And it goes to the order of what should be applied, similar to what you're arguing. Is there any comparison to other types of insurance claims to this type of claim? And I know I'm catching you off guard, but.
Yeah, I'm sorry, I'm not familiar with that case,
Thank you.
Justice McEvers. I'm not equipped to really squarely answer that question. I'll do my best here, but I'm not sure I understand in the insurance context versus this setting here, where it's a sequencing of damages with comparative fault and the cap statute here, the non-economic damages.
The only comparison is there's a cap, there's a cap in that as well, and what the order is of when you apply the cap before or after economic damages. But it was kind of an off-the-wall question, and I'm sorry if I caught you up.
No need to apologize. Thank you. My time is 5 seconds left. I'll conclude.
Thank you, Ms. Kolb. And Mr. Severson, you have 5 minutes remaining.
Thank you. I want to first start with back to the waiver argument. Not only is there Tyler versus Shea in 1894, but this court also decided Brunswick Court versus Harder in 1971, which we cited in our brief, that says appellate review survives acceptance of a benefit not placed in jeopardy by the review sought. The review that we sought was the $1,034,000 that was taken off of the amended judgment because of the cap. There was a 2022 decision in this court, it's in the family law context, Fikert v. Fikert, where it says voluntary payment rule, meaning what voluntary payment would have been from CHI, you abandon in cases of partial payment where the challenge is limited to disputed claims. I think that also could apply to what they're saying. If they truly intended, or what their intent was to pay the full amended judgment that didn't include the amounts that we are disputing. That is their own waiver of their cross appeal. So I believe this court's prior precedent on that says we did not waive because we're asking only for amounts in excess, but that they did by making the payment for those amounts. On the amended judgment that was paid, that did not include the amount of that $1,034,000. That's what so when we say a satisfaction of that judgment, that is not saying there's a satisfaction of the remaining dispute about the constitutionality of 324202. As far as the allocation of fault, Chief Justice McEvers, I guess I hadn't thought of that case either, and I don't remember the particulars of it, but I think the distinction is that's economic damages, which are particular, where the jury, you can kind of get a calculator out. This court's talked about that, versus non-economic, which even in Condon was talked about, being different types of damages that are actually specially reserved in North Dakota for the jury to make determinations on. So I think that's the difference of the analysis. There, we're trying to make sure about the recovery on something that's specific and the amounts that would be reduced after that. I think this is a different analysis where the legislature has tried to cap damages at $500,000, and the important language in there, it says awarded. Why is that important? The only defendant that was at this trial that had any damages awarded against it was CHI. And if we look to the...
So when the doctor settled out, that wasn't an award of damages because it wasn't awarded by the court?
That is correct. And in fact, I think I didn't brief this either, but it occurred to me looking at this is this court encourages resolution of claims rather than trial. And there's Perringer releases and all of that talk about that. That's the risk that we are accepting, and I think we could look at that analysis as well. But on top of that, we have to look about the comparative fault statute was in place before the cap. That has to apply first and then the cap. We briefed that out in ours. So I believe for all those reasons, the district court made the right decision on this. And in fact, if you look back to the oral argument on this, this wasn't fully briefed out until we had the argument. And then CHI asked for additional briefing. The court allowed it. We fully went through it. The district court judge, Judge Shuey, she looked very clearly at this and made what I believe is the reasoned decision on that. So in closing, because what this case is about, 324202, in the context of a medical negligence claim, that at the time that the Constitution was put in place under Section 13 of Article 1 and Section 20, because that said that the limit was that the legislature couldn't take away that inviolate right. The fact that they reduced the damages through legislative action shows that they overstepped their bounds. And I believe that's why it's this court's requirement to say that was too far. And in this context, under this particular analysis for the constitutional framework, it's unconstitutional. Thank you.
Thank you, Mr. Severson, for your argument this morning, and Mr. Johnson and Ms. Kolb for your arguments as well. This case will be taken under advisement, as all cases are, and we will be adjourned until 1:30. For the students here, there will be a justice or justices in here with you in a few minutes. So please hang on. We'll be right back.